Good morning, good afternoon, good evening. Thanks everyone for joining us this day. I was this morning for a very, I think, timely discussion around some developments that have happened, particularly in the U.S. And EU relationship regarding transatlantic data flows. So we'll be digging into some of the details. But first, I want to say thank you very much to our distinguished panel. We are quite fortunate to have some terrific expertise with us today. We are a bit heavy on the DOJ side, I noticed as I was reminding myself of all of our histories, but we also have some other experience, and I'll try to keep my DOJ, Department of Justice, championing in check today. So I will go in alphabetical order and briefly mention first who we are at the Institute for Security and Technology, where I sit as the Chief Strategy Officer. My name is Megan Stiefel. IST is a 501c3 nonprofit organization. It's based on the West Coast and Silicon Valley, and we work to confront emerging security issues presented through and with technologies. We work on a range of these issues, including nuclear command and control, the implications of artificial intelligence, strategic balancing, particularly thinking about the relationship between the US and China. We're working, and actually later this week, we'll release some research that we've completed around digital cognition and democracy. And we also work on cybersecurity issues. So last year, we were fortunate to convene the ransomware task force. You can find much more about our work online on our website. So turning to today's topic, I am super excited to be joined by our panel. I'll start with Anitha. Anitha joins us from AWS, where she works on issues related to cross-border data flows, cybersecurity, data protection, privacy, and content moderation. Anitha also has a lengthy history at the Department of Justice following her time at DOJ, where she served in both CSIPs and CIOS, the Children's Exploitation Section, as well as ESU, the Electronic Surveillance Unit. She spent some time at Verizon, where she was there for 3 years in the legal department as senior director, overseeing operational and policy aspects of the organization's global compliance framework. As I mentioned, Anitha now is at AWS. Next, we have David Criss, who at one point in time was my boss at the Department of Justice. Among other things, David literally wrote the book on FISA, but he is now the one of the co-founders of Culper Partners, where he is counseling a range of organizations on issues related to national security, surveillance, cybersecurity law and policy. David has more than 30 years experience, as you can see on the website, in the private sector, government, and academia. He was also a first-rate leader for the National Security Division at DOJ. And finally, and certainly not last but not least, Peter Swire joins us as well. Peter has been joins us from Georgia Tech, where he is the Elizabeth and Tommy Holder Chair of Law and Ethics in the School of Cybersecurity and Privacy. He's also counsel with Alston and Bird and a research director on the cross-border data forum, Peter is an absolute distinguished expert in privacy issues. And so we have a broad, I think, representation, both reflecting the implications for these developments in the industry, but also an ability to speak with experience and expertise on how the US government in particular, is thinking about the implications for these recent developments. So welcome, panelists. I wanted to kick off the conversation by a little bit of history. So some in the audience may not be as familiar with what it is that we're talking about today and how we got here. So I first wanted to invite David and Peter, and I'll invite David to turn on his camera because he does have all powers known to hosts, to talk a little bit about not what happened in October and not what happened in May, but what led to what happened in May. Some of us know this phrase as Schrems II and the outcomes of several decisions by the European Court of Justice. But can you talk a little bit about both procedurally and kind of perhaps in the broader trade and diplomacy space, why it is that we find ourselves in this point today and how we got here? David's talking, but is on mute, and Peter is unmuted. Okay, there we go.
Peter, you lived it, so you may be the best equipped to speak through it.
So, I think the place to start is that Europe has these strict privacy laws, which are now called GDPR, and it used to be called the Data Protection Regulation. And if there's a rule in your jurisdiction that you're going to be strict on privacy, and then you ship the data somewhere else, you don't want everything posted on the internet indiscriminately. And so to protect against that, to protect privacy, Europe says you can only send it to places that have adequate protection of data. And the first round of this was the Safe Harbor, which was signed in 2000 when I was in the Office of Management and Budget working on these issues, which basically said when data left Europe, that it would come to the United States from the companies who signed up for it. The companies promised to treat the data as if it were still in Europe with the same level of protection as it was in Europe. And that lasted 15 years until the Court of Justice had what's now called the Schrems I case. And the court did not criticize how companies dealt with the data. Instead, to a lot of people's surprise, they said the real problem when it goes to the United States is that the NSA does too much surveillance. And there has to be protections against government doing too much invasion of privacy. That led a few months later to something called Privacy Shield, which is the second round of agreement between Europe and the United States. And in Privacy Shield, the US agreed to various promises and changes around the US government actions. That got challenged in court in Ireland. I was one of the expert witnesses in the case. And it went back up to the Court of Justice. And in the summer of 2020, the Court of Justice for the European Union, their Supreme Court for European Union things, said Privacy Shield wasn't good enough, that the government of the US had not made strong enough protections here. And they said there's two problems. The first is, under European law, data can only go someplace where the surveillance by the government is necessary. There has to be a good reason for the surveillance, and proportionate. Proportionate means there can't be too much of it. You don't have an excuse of national security and then you can do everything. It's not a general warrant. You have to be proportionate. And they said the US did not have a system to limit surveillance to necessary and proportionate. The second issue was redress, which is in Europe, individuals have a right to go to the people who are controlling the data and say, hey, check out my data, make sure you're following the rules. And the European court said that applies actually to the NSA, that somebody from Europe can go get the US government to look at whether the data was handled properly. And there has to be a system for checking on that. That might seem surprising to American ears that somebody in Europe gets to check whether the NSA is doing improper surveillance, but that is a requirement for the European law under their Charter for Fundamental Rights. It's not GDPR, it's their constitutional document. And so as of the summer of 2020, there were these two reasons that things didn't work. And there's been long discussions about what to do about those, and we'll get into the details about them. But fast forward to October 7th, President Biden issued an executive order. And he also told the Department of Justice to issue regulations, which they've done. And the executive order and the regulations have a new structure to say it's only necessary and proportionate, and to have a new structure for redress. And so that then is the US legal response after long, long detailed discussions with the European Commission. And that was what was announced earlier this month. So I think I'll stop there.
Thanks, Peter. David, I wondered if you wanted to add anything further to Peter's excellent summation or...
No, I thought it was terrific. I'll just say, to add one aspect, which is the stakes here are terribly high, because if transatlantic data flows are forbidden or interrupted as a result of all this, transatlantic trade will suffer. And we are talking there about very, very large sums of money, very, very major economic activities. So this is an extremely high stakes endeavor that we're all engaged in here. And it needs to go correctly. It needs to be resolved favorably, or we're going to be in a big mess.
Thanks, Anita. I wonder if you can build a bit upon that. So thinking back to kind of where we were before the agreement in May, which we'll dig into a little bit in a few minutes here, how can you speak a little bit to how the business community was impacted by the phase that we were in pre-May and now pre-October 2022, and how the impact that it had particularly on your customers?
Yeah, thank you so much, Megan. And thank you for inviting me to this panel to speak with Peter, alongside Peter and David. So as Peter mentioned, Schrems II ruling, Privacy Shield was invalidated. The EU Court of Justice did continue to uphold the use of another transfer mechanism called standard contractual clauses for businesses that could be used to transfer data. And so after Schrems 2, businesses began required to undertake a very detailed case-by-case data transfer assessment. And then depending on the type of assessment, the outcome of the assessment, required to implement supplementary measures in order to rely on those SCCs for data transfer. And just as a data point, a survey from Digital Europe estimates that 85% of all EU-based companies transfer data outside of the US, outside of Europe, using standard contractual clauses. So as part of this assessment, companies have had to conduct an analysis really of whether another country's laws and surveillance practices offer a level of protection equivalent to EU laws. Conducting this kind of assessment has usually belonged to the Commission, using legal experts like Peter, undertaking a significant period of analysis, and drafting an adequacy decision. But following Schrems 2, that really fell upon businesses directly to conduct that comparative legal analysis and assessment to private and public organizations. And of course, that's been a significant burden and very complex analysis, with the need to really adopt a number of new expertise and resources within organizations to be able to conduct that kind of analysis. So, I think we often think about the impact of Schrems 2 through the lens of big tech companies from America. But what we've actually seen is that there's been extensive impacts to European-based businesses, particularly small and medium-sized businesses that were the ones primarily relying on Privacy Shield, and then had to undertake these extensive obligations following the Schrems 2 decision.
Thanks, Anita. I think it's a great point. All of the points that you made, but particularly the impact that this has had on the small and medium-sized enterprise community. We often talk about, and one of my probably used too often talking points is that these small and medium-sized enterprises are really the lifeblood of economy, of the global economy, not just in the United States, but really internationally, and particularly in the EU. I was just looking at the fact sheet that the White House put out when the agreement was signed, and it notes in there that the transatlantic data flows are enable a $7.1 trillion economic relationship between the US and the EU. That is huge. So as David said a few minutes ago, we really do need to get this right. So I think it's probably time for us to move into what it is that we are trying to get right here. So as we mentioned, Peter just mentioned, so on October 7th, the president did sign the executive order to implement the European Union US data privacy framework, which was agreed to in May. Before we get into the details of that EO, though, executive order, which is because so many of us talk in shorthand, that's what we will probably use that phrase pretty often. I think it would be useful for us to turn to both, particularly Peter and David, to talk a little bit about what the significance is of an executive order. What is its relationship to the United States Code? What are the impacts of its durability? How enforceable is it? What would it mean for an agency or department of the United States government to violate the executive order?
I think David's experience with the National Security Division would be great background for how it applies in national security setting.
I'll start then. Yeah, I think this executive order is going to be and is clearly understood by the IC and DOJ. That's IC for intelligence community, and DOJ as binding. As an integral part of U.S. foreign intelligence surveillance law now, and as durable, both in the formal sense, meaning it will endure unless and until rescinded by a future president in the same sort of way that other legislation or other directives are. And empirically, I expect it probably will endure if it is deemed by the Europeans to be adequate to its stated purpose. So an executive order is binding. It may not be that easy for people outside of the US legal tradition or those without a lot of experience with the intelligence community in the executive branch to understand how absolutely, seriously an executive order will be taken by the IC, by NSA and other branches of the intelligence community, and by DOJ. But there's a very long tradition in the United States of executive regulation of intelligence, And perhaps the most prominent example of that is the executive order known as EO 12333. That's the 12,333rd executive order since they started counting, I believe, shortly after the Civil War. And that order, 12333, is, really in many ways, I think the closest thing we have to a charter document for the intelligence community. There were certainly statutory rules that are significant, to include the 1947 National Security Act, but 12333 is really pretty close to the spinal column of the organization, in determining roles and responsibilities and limiting collection and other conduct by the intelligence community in a whole host of ways. And that order, although it's been amended once or twice, has endured since it was issued by President Reagan in 1981. It followed up on orders issued by President Ford and then by President Carter. So there's a very, very strong tradition of presidential and executive branch regulation of intelligence matters in the intelligence community. And I think this new order will be seen in the context of that tradition. It will be understood as binding, as mandatory, and as something that cannot be flouted or ignored. It will be taken very, very seriously by the people who are charged here with administering its various elements.
I have a follow-up question, if I can, to David, or I'm the only one here who hasn't been a prosecutor in the Department of Justice. So I see an executive order as a lawful order by the President of the United States to military personnel who do intelligence. So now he's commander-in-chief, and also to non-military people in the intelligence community to act in certain ways. And I'm curious if an employee in one of these agencies violates this lawful order, are there consequences? Oh my goodness. I'll move my body and the lights will come back on in a minute. But we're in the shady part of intelligence here, spy stuff. In any event, are there consequences for employment if somebody in the intelligence community violates a lawful executive order in terms of personnel actions or other actions?
There certainly can be. And those may not be dished out by the Department of Justice. That's when you're getting beyond personnel matters and getting into potential, criminal violations. And there are, as you know, a number of criminal laws that can apply to misuse of intelligence authorities, surveillance authorities included. But certainly there are employee discipline provisions. And you see this every now and then. You will hear a story, a release will occur from an inspector general or otherwise about examples of, what's called love-int, where someone with access to intelligence collection tools will use them to check up on a boyfriend or girlfriend or whatever. And this is clearly improper. It's an outright violation, and there are consequences that follow depending on the particulars of the misconduct. And so there certainly is an option. And the president is the boss, not just of the military as commander-in-chief, but of the whole executive branch under the vesting clause of our Constitution. And the Supreme Court's been quite explicit. In fact, recently, as you know, Peter, the court has been very strong in emphasizing presidential control, or even over and against congressional efforts to limit the removal of people within the executive branch or broadly within the executive branch. So that the president is the boss, and the rules that flow down from him and through the cabinet secretaries and down through the cascade of the federal bureaucracy do require adherence to lawful directives. You're not going to the military brig on the civilian side in the same way, but you certainly are required to obey, and there are consequences if you don't.
I think that just for the discussions with Europe, documenting what you just said, David, would be part of building a record so people understand these sort of arcane aspects of U.S. law. Because my sense is that executive orders have to be taken very seriously. And there's been lots of criticism from Europe that it's just a bunch of words from the president. And so documenting the criminal and other consequences, I think, would be useful.
I can remember, just to take the moderator's prerogative and interject here. Wow, that was not supposed to happen. The amount of training that we spend, the U.S. government spends to bring its employees into a routinized use of the authorities that are granted to us as a former employee, rather, is significant, and it is, not a matter that's taken lightly by anybody. I think, certainly I find myself cringing at times seeing things that I should not belong in the public eye that have been potentially obtained through those practices. And I think it's something that's really ingrained in the staff, all the way from the bottom to the top, of how significant the authority and the capability is, but also how significant the responsibility is to exercise and manage that information that's obtained that way, consistent with the policies and procedures that are directed by those EOs. So that's probably a good opportunity to make a bit of a pivot, but I wasn't sure, Peter, if we wanted to talk anything more. You posed the question we were talking about a little bit about yesterday, about sort of how significant is it that an EO, I'll say it this way, which perhaps is not the most diplomatic way of saying it, but made it through the interagency process. And I think maybe it's worth spending a minute, David and Anita, David's laughing in particular, I think about thinking back to 1233.
Yeah, there's probably scars on anybody who's been around government of the United States, where just what happened here would have been that the U.S. team working on these issues would have included the Department of Commerce, which is very concerned about having trade with Europe. It included the Department of Justice, getting all the legal rules right. And it included all of the intelligence agencies, which vertically go up to the Office of Director of National Intelligence. And I've heard that there were, back and forth between, which often happens, where, sometimes they say in Washington, where you stand depends on where you sit. If you're in an agency and you're seeing risks to important programs or goals of your agency, then you defend them. And I'm sure the intelligence community scrutinized the language of the draft executive order and really tried to make the point they could only comply with things that they could comply with, and didn't want the executive order to go beyond what was doable in practice and what was wise in practice. And that's a normal part of issuing an executive order. It gets read by a lot of eyes before it's issued, including everybody in the White House, more or less, lots of different offices. So, I do think that this will be something. I was on another call earlier today where there's a provision, this might be getting into the details, but there's a provision that lists what the permissible purposes will be going forward, and it's only necessary and proportionate if you do these purposes. In Europe, there's been criticism saying, well, but the executive order gives permission for the government to come up with additional purposes in the future and not necessarily say that publicly. And from the European side, that might look like a blank check to go add extra purposes for extra surveillance. And I've wondered, maybe the intelligence community was just saying, we don't know what's going to come up next that might harm the country or the world, and we need to have some room to address that. But I do think that in Europe, they're likely to push on that point and say having secret additional purposes really takes away the protections that seem to be there from the list of purposes. So I don't know if the rest of you have any observations on that, but that seems like an area where you can expect criticism going forward.
I mean, just to follow up, I guess, on that, I think some people say, well, it's just an executive order, so, it can be changed at the discretion of the president through just one branch of the three, rather than the two that are normally required for legislation, statutory changes in the United States. This is perhaps an odd criticism to be leveled from governments with parliamentary systems, but regardless, it is true that an executive order regulation can be changed using only one of our three branches of government. But it is also true, and there's been some scholarly work done to document this, to which I'll add my own personal experience anecdotally, that executive orders and DOJ regulations are taken extremely seriously. And you can see that not just in the sort of scholarly work on how the process works in the interagency, and I'm obviously not commenting on anything about that I've heard about this particular process from non-public source, but the amount of time it took to get this done. The thing was, in development for over a year, they said publicly when they announced it in March, and it took them then, 6 months to get the documents done. And I don't think they were sitting on their hands. I am confident, without having any access to insider stuff here, that there was what the State Department would call a full and frank exchange of views, in the process that led to these things. They're very, very serious. I mean, I think, and Peter, I think you're right about the, objectives. They define here, I think in a way that is unprecedented, 12 specifically defined legitimate objectives for collection, and several that are illegitimate. And that is a refinement in public-facing materials as against the prior baseline, which was sort of, you can collect foreign intelligence. That's the statutory standard, a term that's defined fairly broadly. I can understand, even if others may not be as sympathetic, the idea that although they've leaned in now and identified these 12 objectives that are legitimate, and they've said that if there are to be changes, they're to be made public to the maximum extent possible, they do reserve in the President of the United States both the authority to add to the list where necessary. I have found in my experience that the world changes and intelligence requirements have to be adjusted as the world changes. It's people as old as me remember the Cold War, the global war on terror. And now you find in public pronouncements from the intelligence community, we're talking about the 2+3 framework, which is, Russia, China, and Iran, North Korea, and violent extremists of all sorts. So you've had an evolution even in, recent years. And there may be cases, and, it may be hard to take, where intelligence work, secret agents have to operate in secret, and requirements have to be issued and aren't specified. In public. I don't think that will be very likely, but I can understand why they reserve the authority in the president's order.
Thanks, David and Peter. I think those are important points that are nuances that are probably known only to those who've been studying this, but hopefully I think you've both done a good job of transitioning them into kind of layperson's terms and or kind of non-scholarly interpretation. I think it would be useful now for us to talk a little bit about some of the additional requirements of the EO. Maybe spend a brief moment on the Section 3 of the order that gives direction to the Attorney General to issue regulations to establish the DPRC. Not the best set of initials, because we do like to speak in initials, but in any event, what does that mean? And we'll introduce you all, the audience, to another phrase that we use often, at least some of us, David probably, and Peter and Anitha more than I do anymore, but the clippo. And then I think it would be great to spend a good amount of time on, okay, what's next? So we'll talk a little bit about the substance here, and then transition to Anitha and the others to talk about both what's next in terms of what's the EU going to do, and then what does this mean for global commerce. So first,
I might take. Well, go ahead. I don't want you to jump in, but
go ahead.
On the redress part, that's where I've spent an agonizingly large number of hours for the last 2.5 years, and so Anitha's laughing. She's seen some of these things in draft. I think for people listening, there's a clever thing that came from the government, from some unknown lawyer in Department of Justice, which looks to previous cases where a Department of Justice regulation can constrain the discretion of the Attorney General and the President. And so the famous one is from Watergate, called U.S. versus Nixon. And there was a regulation from the Department of Justice that said the special prosecutor could ask for certain documents. And then the President and the Attorney General didn't like what he was asking for. And the Supreme Court unanimously said, well, the regulation's in effect. The special prosecutor under the regulation deserves to get this, and so he has to get it. And that was the sort of power of the regulation over the Attorney General and the President, who didn't like it. And that's cited approvingly in an earlier case called Accardi that had to do with immigration judges. And again, there was a Department of Justice regulation. The regulation said that the Attorney General was giving up his discretion and letting the immigration judges make decisions on deportation. And then the Attorney General didn't like their decision. Supreme Court said, wait a second, there's a regulation. The regulation wins. The judge's decision stands as independent decision. You can repeal the reg, but you haven't done that. And so the regulation overcomes objections by the Attorney General and the President. And so with these really clear Supreme Court decisions that reaffirm the rule of law aspect of a Department of Justice regulation, DOJ issued that regulation on October 7th that put all these guarantees of independence and of effectiveness into place for how this data protection review court would operate. And the legal structure is probably not familiar to almost anybody ahead of time. But I was watching David, I think, nod at some of this. While the regulation's in effect, it has binding effect, it is law, and it can only be repealed with all the procedures it took to put it in place in the first place. And so that's law, and that's independence, and that's the core answer to concerns from Europe about who are these judges created by the executive branch. The answer is this magic regulation has made them independent, and as long as the regulation's in effect, they stay independent.
Yeah. I'll just second what Peter's analysis there. I thought it was excellent, and the government in rolling this out did talk about the Nixon case and the importance of regulations being binding, even if they could be rescinded. But while they're on the books, they have to be followed. And Peter's done some very fine scholarly writing about that, in fact, some time ago. And I think that's exactly right. There's a whole bunch of other stuff that's going to happen as a result of this, apart from setting up the new DPRC. Many people want to try not to say DPRK when they say it. I just call it the new court. But it is within, I think, the traditions of executive control over intelligence, at least when it comes to adding restrictions, as opposed to trying to empower things above a statutory floor. The president could tell the intelligence community, don't do SIGINT on Tuesdays. That would be weird, but he can do it, and he can cascade, authority like that down. And in fact, by the way, in the early days of SIGINT, this is going down a rabbit hole. Literally, the Army and the Navy split up SIGINT collection responsibilities such that on the odd days of the month, one of them did the collection on the target, and the even days, the other one did. So sometimes pressure produces weird solutions that are adopted within the executive branch, but it's not outside the realm of the possible. So the president has authority to cascade that, authority down, again, in ways that limit. We're not getting into any, big separation of powers, Youngstown sheet and tube contests here where the president's trying to say do more SIGINT than the statutes permit. He's saying restrict your SIGINT or, give rights. So I think that's the way to think about, what's going on here. And they can, within certain legal limits, delegate the authority out to these other groups, this new court. But there's a lot more going on here. There is the CLIPO. There is within the Director of National Intelligence's office a person who also is a former DOJer. Let's acknowledge the mafia as it spreads its tentacles. A very fine gentleman named Ben Hubner, who's the Civil Liberties and Privacy Officer, CLPO, or CLIPO for short, who works for Avril Haines, the DNI. And he has a wonderful new responsibility here, which is to review and assess, under criteria set out in the executive order, any new intelligence priority that is submitted by the DNI for approval to the president. So by way of background, our intelligence community doesn't just decide for itself what it feels like collecting that day. We don't delegate that kind of authority down to the agencies in an unsupervised fashion. Instead, there is something called the National Intelligence Priorities Framework. And that is a framework that identifies the priorities for collection. So go out and determine the order of battle of the army of the government of Zendar, for example. Okay, that might be a thing the intelligence community is instructed to do. Because why? Because national leaders need to know what that army is capable of doing for reasons of geopolitics or otherwise. And so there's a process of communicating the priorities to guide the collection. And that process involves presidential sign-off. And now that process involves a sign-off and review by the CLIPO within the ODNI. Now, it's not that he can actually veto the president's determinations on this, because, we do have the executive branch that's structured hierarchically. But it is the case under the order that if the DNI does not agree with the CLIPO, and the CLIPO says this is a bad priority, you shouldn't do it this way, it's too broad or whatever, that assessment must be brought by the DNI to the president when the National Intelligence Priorities Framework is being validated. That's a non-trivial change, and I'm sure Ben is feeling wonderfully empowered. That's only one of several things that's going to have to happen as a result of this order, but it's a notable one. And I'm happy to go further and talk more if people want, but that's just as another thing that's going to change here. That's a big one, I think.
So I think it's worth just dwelling briefly on the point that hopefully is coming across here, which is to say that there are multiple layers of checks in this system, that it is a system that has, or a process that has a lengthy history. And to be very clear about this, it doesn't change very easily. And so the fact that we have this change is maybe monumental is too strong of a word, but I don't think so. And I think we should really spend some time thinking about what I mentioned a couple of minutes ago. So first, I think to bring Anita into the conversation, I assume there was some degree of like valiant cheer coming from the business community, although we're not there yet. And so we'll get to that. We're not quite to the finish line. We're almost there. I think we can see it. And we'll talk about kind of the signals that we've seen at the finish line. But just sort of to talk a little bit about how the business community is thinking about this change and again, coming back to what does it mean for customers? You had described a particular development that I think is worth sharing and spending some time on.
Yeah, so thanks, Megan. So, one of the things that has happened since the Schrems II ruling and the requirements on businesses that I described before is also just the varied interpretation of the ruling within EU jurisdictions in practice and implementation. So there has been kind of a variety of regulatory interpretations of this, and organizations in the EU have really had to operate in this fragmented landscape, which has led to a lot of lack of clarity for organizations in how they conduct their operations. And that uncertainty has existed really for the last few years. So I think from the collective business community, having the executive order in place is very significant and helps bring some of that clarity into focus. And of course, what's kind of next is the European Commission is undertaking its adequacy decision to formalize the actual framework. So I don't know if Peter or Chris David have a better way of describing this, but it seems the EO is kind of the US side of the framework, the adequacy decision as the EU side of the framework, because I've had a lot of people ask me, oh, is the framework in place now? And kind of describing it as, a step on each side. And then the official framework will come into being. But I think importantly, the new safeguards set forth in the EO and DOJ regulation do come into effect in US law immediately. So these are important steps that the US has already taken. They're not waiting for the adequacy decision to implement those safeguards. So what this really does bring is it helps bring that clarity that companies are looking for when they can undertake their assessments and use these new protection safeguards in the analysis and assessments that they do. And the European Commission has already issued a question and answer sheet in which they've actually characterized some of the new safeguards. I thought significantly, they said that in these negotiations, they've tried to provide a durable and reliable legal basis for transatlantic data flows and identified a significant improvement from the safeguards that existed with Privacy Shield. And so I think all of these areas of new protections within US law are going to be taken in by the business community, especially those relying on those SCCs to conduct their analysis, and they can undertake that into their immediate analysis. But I did want to kind of give an example to highlight why enabling data transfers really is so important, and how actually enabling data transfers can actually improve data security and data protection. And one of the very important examples we've been discussing within the business community is, of course, and lots of different communities, is of course what's happened in Ukraine over the last 6+ months. And when the Russian invasion happened of Ukraine, AWS and a number of other tech companies worked to assist the government of Ukraine in the days and weeks and months after the invasion to really secure their data, their government data, their public sector data. Ukraine is, of course, in a different legal framework than EU countries. We don't have the GDPR application there directly, but what is important is the fact that the regulatory environment there did allow for that kind of swift action to safeguard data. So just before the Russian invasion, actually, the Ukrainian law required certain government data and select private sector data to be stored in servers physically located in Ukraine. And about a week before the invasion, the Ukraine parliament actually passed legislation to allow the government and private sector data to be moved to the cloud. And of course, AWS is a major cloud service provider. We worked quickly with counterparts in Ukraine to securely move Ukrainian government data to the cloud. And of course, that is that's been hugely important for the Ukraine government to ensuring the continuity of government services. Some of the work that's been that's actually benefited from this, is much more human impact. We can talk about all the critical government data, which, just basic things like information of educational degrees and university curriculum, moving those educational records to the cloud allowed for students to actually finish their school years in new locations. Scientists were able to move a number of their data to the cloud, including one project which was monitoring air quality and radiation levels near nuclear power plants close to conflict zones. These are really, obviously hugely impactful situations where just the migration of data enabled some really significant things to happen in those days, weeks, and months, and as we continue here. And of course, Ukraine is an acute example, but I think going back to what, David and Peter said before about the unpredictability of the environment, the nature of national security threats, this really does highlight, the importance of how swiftly governments may need to move in really rapidly changing situations, and why those trusted data flows amongst allied countries is so important in the digital world that we live in today.
Can I just follow on that? I found that extremely insightful. And actually, Anita reminds me to say that I do have clients in this space, but I'm here speaking only in my individual capacity. But I think the geopolitical lens for this is so interesting. First, it highlights the broader importance of figuring out these cross-border data rules internationally so that data can move. And it's sort of fascinating if you look at Ukraine. There's been a trend, I think many people decry it, towards requiring data localization. You must keep data pertaining to persons from our country in our country on servers physically located here. In Ukraine, I think what Anita's describing is a little bit an opposite trend, which is that if you think at any moment that Russian cruise missiles or tanks may roll across the border, you might actually impose a different requirement, which is you must keep a copy of the data somewhere else, so that if we lose territorial integrity for a moment, we will still have access to the data. So I think, it illustrates broadly the importance of getting all these rules figured out so that, commercial activities and other activities can continue. It also illustrates the unpredictability in terms of what the ground level rules might be. I think it does sort of make one think that adaptability in approach may be necessary, and the tremendous importance of the private sector. AWS hosts any number of governments and private sector entities' data, and if those data are in jeopardy, you've got real problems. It's bad for business, the kind of chaos that we've seen in Ukraine. So there's lots of reasons why governments and private sector entities would like nice, stable, predictable rules here that allow, easy transfers of data across national lines where needed.
Maybe I can pick up for just a second. I've been doing a research project with some co-authors on how this data localization trend harms cybersecurity. For instance, if you're inside one locality and you need a service to help you with some cybersecurity problem, that service can't operate software as a service from outside your country, and you're barred from getting access to a effective security service. Another one in current research we're looking at is defenders for cybersecurity want to watch their systems to see if there's horizontal and vertical movement where the bad guys try to escalate privileges. Well, to track what's happening for escalation of privileges, you have to watch the accounts and the different usernames and the different activity that's happening in your system. If some of that happens in different countries, localization can disrupt your ability to spot the intruder in your system, which is just a crazy result. And so one article has been published, the second we have in draft on how these localization rules really get in the way of normal cybersecurity protection, and it thus creates risks that to people's personal data and to businesses that people haven't really been paying attention to.
Yes, I think I'm appreciative to all of you for bringing in this sort of broader question around data localization and thinking not only about the business implications, but then about the human costs that can flow down from the uncertainty that was in place. And I mentioned, and so we'll spend the last couple of minutes, I think, speaking maybe a little bit more about kind of what does come next. So we are not yet to the finish line, as I described a few minutes ago, but Anita mentioned the question. I think it was Anita who mentioned the questions and answers that the commission has already shared, and so I think I'm told by our experts that those are positive indications. The signals are good, but why don't we spend a few more minutes talking about what the EC is kind of telling us they're likely to do, and then I think we can wrap things up.
Anita, do you want to do that?
Sure. Yeah, so as I mentioned, the EC has issued a question and answer sheet to kind of talk through some of the initial questions that folks may have about what the new executive order safeguards are. And they are now undertaking, the draft adequacy decision, doing the analysis. I am not a super detailed understanding of EU legal procedure, but I understand they'll submit that to the Parliament and member states for approval. And there may be additional opinions issued, including by the EDPB during that process. But yeah, Peter, please chime in if I'm messing any of this up.
I'm sorry, I didn't know. So there's the draft decision that will be coming out, who knows, in a couple months. Then the Parliament gets to comment on it, the European Parliament, but they don't get to block it. The European Data Protection Board, which is the regulators for privacy, get to comment on it, but they don't get to block it. Then the Commission goes back and takes those comments and comes up with a final adequacy decision. At that point, there would be a decision of the Commission that this is good enough to allow data flows. And the guess has been 6 months from the date of announcement, as I'm sorry, I'm getting noises in the background. 6 months from the date of the announcement, which is October plus 6 is April or whatever, is roughly the time frame. And then Mr. Schrems has promised he'll sue as soon as they issue the final proclamation. And there's some mystery procedurally, as I understand it, in the courts. Schrems Group NOIB has said that they will seek an expedited appeals process. I've heard others say that there is no such expedited appeals process that would happen in practice. So last time it took, something on the order of 3 years from the time Mr. Schrems began his case till the Court of Justice made his decision. Maybe it'll be 3 years till the next time. Maybe it'll be expedited. It's just really hard to say, but there will be ongoing uncertainty simply because the Court of Justice has been, quite strict on data protection, including, rejecting data retention requests by the law enforcement and national security people in Europe, in the member states. So they've been skeptical towards their own governments about government surveillance for national security, and they've been very skeptical towards the U.S. So with that as the highest court, there is uncertainty going forward, but we have some period of time before we'll get their word on that.
And, if I can, if you'll indulge me, Megan, I guess just one more additional layer of uncertainty or complexity, at least on the U.S. side, which is this elaborate redress framework that has been set up by the executive order and the new regulations issued by the AG is applicable only to qualified complaints. That's the defined term for covered violations that are coming from qualified states. And a qualified state is one, either an individual country or perhaps a regional economic organization. I wonder what that could be. That has been designated as having an adequate level of protection for U.S. persons' data and designated by the AG, Attorney General of the United States, using criteria that are specified in the executive order, one of which is whether it is expected that that qualifying state will be willing to engage in commercial and permit commercial data flows back to the United States. So, there's the legal regime that's being established on the US side, and it's established in large part, but it has to be activated for any individual other state or EU in order to become something that Mr. Schrems or others can then use to file complaints and seek the redress. And again, some of that qualification process looks at whether and to what extent the EU or other states are providing adequate protections for US data and whether they are going to permit data flows back to us. So there's a little bit of a chicken egg thing going on here that's just worth noting as an additional layer of complexity that has to be worked through. To be clear, I do expect a designation from the US side, but it just hasn't happened yet.
Peter, did you want to come in a little bit further on that?
No, I think, David, this reciprocity provision was a sort of surprise in some ways. It hadn't been flagged previously. And it does, I think the United States government has felt frustration sometimes of having to sort of take whatever the Court of Justice comes up with. And with this reciprocity provision, if the United States believes that Hungary or other member states or Europe in general is not living up to its side, then there are consequences back. Europe would lose these rights of redress. And if Europe restricts trade, then the protections here would go away. So there's at least something that Europe has skin in the game in now than a way that it didn't previously.
Yes, I think that's a great point. Having been in the case of trying to manage some 2013 developments that led us to say, okay, we do have a great system. And so I'm going to take the last few minutes of this to actually talk a little bit about that. What does this mean for the sort of global normative discussion around data and privacy and security? I think, as I was beginning to say in the beginning, trying not to exercise too much of the moderator's prerogative, I think we do have a great tradition of respecting privacy, both in the US, but also in the EU and in democratic nations. So what signal are we sending to the rest of the world? Thinking about a particular few set of countries that have been mentioned here, but there are a few others we haven't yet talked about. Are we living up to our values? And I don't know if anybody wants to take the first opportunity to say, heck yes, we are. And here's more. I think some of the points in particular that Anita raised really drive home the need for this particular data exchange and the certainties and the rights and processes that govern it.
I mean, I'll just step in to say that I think the point about allied countries and like-minded democratic countries, rule of law countries, coming together to recognize what are those baseline standards and protections is just so critical. And we've got, the EO and the what we expect will be the framework to really help establish and build that transatlantic trust, which has been strained in the time since Schrems II. And just what that means in terms of being able to elevate some of those developments into broader broader processes. And specifically, I'm thinking about the OECD process on trusted government access. I think we see that as another really critical avenue to help build some of this consensus. I think some of the work that's been done in the EO can hopefully be helpful in that process as well. But that's another place where we think there's a real opportunity here to come to that consensus, because businesses, which often are at the crux of some of these really challenging data issues, and can really serve very critical roles in some of the geopolitical situations, are caught in the middle. And so we have to find a way to come to those commonalities and understand how to work in that interrelated world of data flows together.
Maybe just a quick thing. There's other issues, as often is the case, lurking under the surface or behind the ones we've focused on. There's been a dispute between the United States and Europe over something called the Cloud Act, which has to do with how governments in one country can get access to evidence that's stored in a different country. And there's scheduled to be negotiations between the EU and the US on this. And it's something that will take attention, because some of the skeptics in Europe are taking the position that even if we have this new executive order, that's still not good enough to transfer data to the United States, because there's other problems having to do with US government criminal access to data under the Cloud Act. There have been cases in lower courts in Germany and elsewhere about this. So hopefully that will stay below the surface, because it won't rise up to become a major problem. But there's additional legal challenges to transfers of data, even beyond the ones that were addressed on October 7th. And at the Cross-Border Data Forum, we keep looking at these things, and there's a lot of skepticism out there about global transfers. And if we want to have something resembling global commerce in the internet that we thought we were going to get, we have to find ways to build trust between allies so that we can continue to do these things together.
David, would you like the last word?
No, well, I've said enough. I just want to say thank you. I thought this was a really interesting discussion, excellent and well produced. Megan, kudos to you, and also to Peter and Anitha. I thought it was terrific. I hope the audience enjoyed it. I certainly did.
Thank you, David. I do want to say thanks to Meta, who gave us support to bring this conversation together. I failed to mention that in the beginning, but we are grateful for their support for this. And I am particularly grateful for the conversation that we just held. I think there were hopefully good insights for the audience. I know I learned something, which is always, happens all the time, because I need to learn a lot of things, but also great to be joined by terrific experts and humans in this conversation. So thanks to Anitha, Peter, and David for joining us today, whether it's your morning or evening, or I think we had some Australian participants, which I think makes it quite late in the day. We'll have a video recording of this on our website, and you can find more information about, in particular, a couple of outcomes that have been mentioned in today's discussion on the registration page. So we hope to see all of you again in one format or another. And thanks again for joining us.
Thanks.
Stay well.